afternoon, everyone. Welcome to our HHQ webinar. We are glad to have many attendees with us today for our webinar on sub-sale and refinancing procedure. Before we start this session, please be informed that all participants will be muted, and if there are any questions, please type in the chat box and we will discuss them during the Q&A session later. Please allow me to introduce our speaker, Ms. Elise Ng. She is a Senior Associate of Corporate Real Estate Department in Hong and Pratt. She regularly advises and represents property developers and individual clients on various sale and purchase and banking transactions. She has also experience of advising on various types of financing, including both conventional and Islamic facilities from initial stages up to drawdown. So please join me to welcome our speaker, Ms. Elise Ng.
Hi, Elise Ng here. So today we will have a discussion about procedures of sub-sale, loan and refinancing in general. So it's just in general. Okay. Sorry, how to? Okay, so yeah, I think maybe we can proceed with SPA first, SPA for sub-sale. So okay, for property in Malaysia, for completed property, property can be either under master title or under title. So under title, it can be under individual title or strata title. So okay, for property under individual or strata title, right? So once you have been appointed by the client to act for the client, so it doesn't matter purchaser or vendor. So it is a good practice to always, after you open file, you conduct a land search to check on the property. And then if the other party is represented by other lawyer, to check on the status of that law firm, see whether that law firm still exists in on Malaysian Bar website. So, and it is also a good practice to always check the bankruptcy status of all parties. And yeah, so upon drafting and finalizing the SPA, to proceed to prepare other signing documents, which we will discuss later. And yeah, so if your client is a corporate, then you would also need to write in to them to request for resolution and their company forms. Okay. Okay, so as for property under master title, same practice, always remember to conduct land search, to check the status of that of the law firm representing the other party on Malaysian Bar website, conduct bankruptcy search, bankruptcy or winding up search, and you also need to write to the developer to check whether this is very important because for property under master title, you will not be able to confirm whether that vendor is the beneficial owner of the property. So unless you obtain the confirmation from the developer. So you also have to take note whether there's a proprietor, because sometimes some property, right, there are developer and proprietor. So whereby you need to write to both. So unless there's a power of attorney granted by proprietor to the developer, then you can liaise with the developer to obtain their confirmation and undertaking. Okay, so same practice to, after that you have to prepare the signing documents, and if your client is a company, request for resolution and company form. Okay, so we can briefly go through the documents that you need for sub-sale. So if you are acting for the vendor, so for property under individual or strata title, you have to prepare CKHT form because you have to submit a RPGT for the vendor. So that doesn't matter if, even if RPGT is not payable, you still need to submit. And then a statutory declaration for non-bankruptcy. This is a very standard document. So if the property is a leasehold property and subject to restriction, then you have to prepare consent form. But some property, right, even though they are leasehold, doesn't mean you have to apply for consent. So you always need to check the land search, check their restriction. And then another important document is a letter of undertaking to refund to the purchaser's financial. So if the purchaser is taking a loan, you will need to prepare this letter. And if the property is encumbered, so means that the vendor has charged the property to his or her bank. So you need to prepare appointment letter because we need this appointment letter to request for redemption statement later on. Then after that, discharge of charge, i.e. Form 16N. And if the vendor is a company, you have to prepare extra document, i.e. Form 41, 42B, and 43. And this document we need to file with CCM. And after that, the other two documents, right, it depends whether you need it. So because some vendor and purchaser, if they are friendly party, so sometimes they might pay the deposit directly to the vendor. Or maybe if there is any differential sum between loan sum and balance purchase price, any difference, they might settle directly with the vendor. So if applicable, then you need to prepare this letter. So another letter is if there is more than one vendor, so you also need to check whether the balance, the deposit, balance, purchase price for apportionment to release to both vendors or just either one of the vendor. Okay. So for property held under master title, you have to take note, some developer, they might request for additional documents to be signed, which is their own format, their undertaking letter, their indemnity letter. So you would have to prepare. Then after that, same documents like CKHT form, statutory declaration for non-bankruptcy, undertaking letter, appointment letter. And for master title, instead of 16N, you prepare DRR, deed of receipt and reassignment. So the rest, they are the same documents. Okay, so if you're acting for the purchaser, the documents might be slightly different. So usually purchaser lawyer will need to prepare the sale and purchase agreement. You have to print out the sale and purchase agreement and memorandum of transfer MOT because purchaser will sign first. So purchaser will sign first and prepare the balance deposit before the vendor sign. And then, and after that is the consent form. Consent form as well, because because there are some documents that both parties need to sign. So if it's required for execution by both parties, then the purchaser lawyer will need to prepare that first. After that, foreigner consent. So if your client is a foreigner, then you need to apply for foreigner consent form as well. And then the rest of the documents, CKHT, ST for non-bankruptcy, and entry and withdrawal private caveat. So you have to enter caveat for your client to protect your client's interest. After your client pay the 10% deposit and after the SPA is stamped. So, but unless, if your client doesn't want to enter caveat, it's okay as well, but you have to prepare a letter, non-lodgement of private caveat to protect our firm's interest. Then caveator's consent. Caveator's consent is a document if it's only applicable for property with restriction. So means that if after you stamp the SPA, you enter caveat, this is to protect the purchaser's interest while waiting for the application, waiting for the consent to transfer. But once you enter caveat, right, you have to give the caveator's consent so that the application for consent to transfer can proceed at the relevant land office. Then after that, ST for first property, if applicable, and Borang I. Borang I is to change ownership for assessment. So for subsale, what we do is usually for quick rent. Quick rent ownership will be changed automatically. Once you submit MOT for presentation. Assessment usually we submit for client as well, Borang I, and we charge 100 ringgit for our legal fees. And then for TNB, Shabas, Indawater, you would have to advise client to attend to the change of ownership by themselves. Okay, and then for property held under master title, same document, SPA, but MOT replaced with a deed of assignment of transfer. And then maybe developer's letter, it depends. Some developer, they will request for extra document, some they won't. Foreigner consent also depends on the particular land office. For example, like KL, property under master title, you still need to apply for foreigner consent. But for Selangor land office, you don't have to. You only need to apply for foreigner consent after strata title or individual title is issued. And the rest of the documents, they are the same. Okay, so you would also have to take note the documents that you need to request from the vendor or purchaser. So during signing, you always need to photocopy IC, make sure it's clear. Scan as well. because some land office they will require a very clear copy of IC. Latest script rent and assessment, TMB, Shabas, inner water, this can be provided to us a bit later. So, but it would be a good practice. It is a good practice if the client can give us during signing of the SPA. Income tax number and filing branch, because TKHD we have to file at the vendor's branch. Income tax number, there's a link that you can check their number, and the filing branch you have to call. If the client doesn't give you, so you have to call. There's a number you can call to obtain the branch. Latest housing loan statement, this is to ensure that the 90% balance is not more than, this is to ensure that the redemption sum is not more than 90% of the balance purchase price and CF. Additional document for strata or master title is high rise. Management statement. This management statement also very important because we need to make sure that the quick rent, maintenance charges, sinking fund, fire insurance for that property have been paid to the management office. And then we also need master fire insurance. As for the purchaser, what we need is just the identity card, their identity card or passport, and their income tax number. Actually, their filing branch is not that relevant. It's not relevant, but it's only for our record purpose. Okay, so just briefly go through the documents that you need for consent application. So, okay, you would always need to check the application form because there will be a checklist of what documents that you need when you submit, when you want to submit for consent. So what we need usually is online submission slip. For example, KL Land Office, you have to go to the portal, generate a form. So client need to sign on the form generated from the e-portal. So after client sign, then you have to submit using the form. And then as for Selangor Land Office, you will also need to go to e-consent to submit, but only for landed property. So we just need a slip. For Selangor, I think not so straight. Client can still sign on the manual form instead of their online generator form. So what we need is the online submission slip. Then after that, original application form with the statutory declaration, and then CTC, certified true copy of the SPA. And then if the purchaser is taking a loan, then as the vendor lawyer, I think we should always have to submit for consent to charge as well, because transfer and charge, they can go in at the same time. We can submit at the same time to save time. And then original official land search report. And if the property is charged to the vendor's bank, you need to obtain letter of no objection from the vendor's bank to proceed. And then latest quick rent and assessment, their identity card or passport. So if if the parties, they are companies, then you have to submit extra document, resolution, their corporate forms, and their CCM search. So just remember, if your client is a company, you always need to cross-check the CCM search with their company forms to make sure that they tally with each other. Then original caveator's consent. And then this is where the purchaser has entered caveat. So if the purchaser has entered caveat before the application for consent is submitted, then you have to submit the caveator consent from the purchaser and registration fee. Okay. So which land office or registry? So usually you look at the title, then you will be able to know. So for entry of private caveat and presentation, you always check whether it's PM, HSM, 3M. So everything ends with M, right? You submit at the district where the property is erected on. And PM, HST, Garant, you submit at the state. You look at the negeri. So if you want to change old title to new title, then you have to submit to daerah, notwithstanding the types of the property. So for application for foreigner consent, you also need to submit at the district daerah. Okay. Actually, here I have few timelines. Maybe we can just go through one or two. Okay, timeline number one, I think for vendor, whereby the property is under title, no restriction, and encumbered to vendor's financial. So usually the time frame, it depends on the SPA, but usually it will be 3 months. 3 months from the SPA date, 3 plus 1, 1 month extension, subject to late payment interest. So, so first thing, right, after you stamp the SPA, Then, I mean, you make sure your client pay the legal fees during during execution of the SPA. I mean, it's a good practice, but some client, you know, like vendor, they might ask you to deduct from the balance purchase price, and some might refuse to pay, I mean, in full. Okay, after you date and stamp the SPA, you have to file CKHT. So I think for vendor, you have to file CKHT 1A or CKHT 502. Okay, because now we have exemption for housing property as long as not more than 3 properties. If you dispose the housing property from 1st January until next year, 31st of December, you will be exempted, not more than 3 housing property. So, so what you need to do is submit CKHT 1A and CKHT 3. 3 is exemption. So, but if the exemption is not applicable, so you need to submit CKHT 1A, the receipt for RPGP and CKHT 502. But vendor lawyer, but the one who need to pay for the RPGP is a purchaser's lawyer. So, okay, let's say the RPGP is applicable, right? The vendor need to pay. Usually in the SPA, 3% retention sum need to be 3% of the balance deposit need to be retained by the purchaser lawyer. So the purchaser lawyer will help the vendor to submit. So after submit, the purchaser lawyer will give you a receipt. Then give a receipt to the vendor lawyer. So the vendor lawyer can submit CKHT 1A together with the receipt and 502. So it will be 60 days from the SPA date. Then as the vendor solicitor, the next step is to request your redemption statement because we need to ascertain the amount owing to the vendor's bank. And then we also need to compile all documents as per our discussion earlier, trade rent, assessment, IC, maintenance, CF, fire insurance, whichever relevant, and then our undertaking letter. So when you act for vendor, the undertaking the confirmation that we need to give is the completion date. When is the completion date and whether differential sum has been paid to us as stakeholder. So if the loan is not 90%, so there's a difference between loan sum and balance purchase price. So you have to make sure that the purchaser has paid to you before you give the undertaking. I mean, before you give the confirmation. So undertaking letter as well, you have to undertake to forward the original title to the purchaser loan lawyer. So we always give undertaking the subject, subject to upon receipt of the same from the bank, from the vendor's bank. So you have to give this undertaking. Then once you receive the redemption statement, and then just have to cross-check the SPA, make sure the differential sum has been paid to us, and the purchaser's bank's undertaking letter has been forwarded to us. Then we can forward all documents to the purchaser loan lawyer. So they will advise for redemption sum. So after we receive the redemption sum, so we have to forward the 16N discharge of charge to the vendor's bank. So, and once we receive the 16N, we have to stamp, and then we have to send again to the vendor, to the loan lawyer, to the purchaser's loan lawyer, together with the original title. So, if the vendor is a company, you have to file a discharge form 41, 42B, and 43 with CCM as well. So once you receive the loan balance, you have to inform the vendor to deliver keys to us because there's a time frame in the SPA. And at the same time, we have to calculate apportionment. So usually the apportionment date, the cutoff date, it also depends on, I mean, you have to refer to the SPA, what date is the cutoff date. I mean, usually for me, it would be the date we send over the keys to the purchaser's lawyer. So you have to forward the calculation to the purchaser lawyer. So once we receive the apportionment from the purchaser lawyer, we can deliver the keys to the purchaser. So you have to advise your client to terminate TMB and Strata's account so that they can get back their deposit. Okay, so this is the first timeline. You act for vendor, no restriction. And then the second timeline, I'm not going to discuss because this is easier. This is for acting for vendor, property under title, no restriction and free from encumbrances. So basically, you just need to prepare everything one shot. Make sure your client give you original title when they sign the SPA. And then once you receive the differential sum, all the terms are complied in pursuant to the SPA, then you can forward all documents to the purchaser loan lawyer. Okay. Okay, so timeline number 3, if the property is subject to restriction in interest. So the 3 months, right, it will be from the date of the consent to transfer, the date of the consent letter. So as a vendor lawyer, you need to request for letter of no objection from the vendor's bank first, because the property is charged to the vendor's bank. So you always need to get their approval. And then you have to compile documents to apply for consent, as discussed earlier. So once you obtain the consent, the SPA will commence. So means that the 3 months, right? 3 months from the consent letter date. So from there, you have to file your CKHD and attend to the necessary. Okay, timeline number 4, acting for purchaser. Maybe we can just discuss one slide now, one timeline. So when you act for purchaser, same timeline, 3 months from the SPA date. Okay, as a purchaser solicitor, you have the duty to pay the RP duty on behalf of the vendor. So if RP duty is payable, so after you pay, then you have to give the receipt to the vendor's lawyer. So if RP duty is not payable, then you have to file CKHD 2A and also CKHD 3. So you have to request for a copy from the vendor's lawyer and file CKHD form for the purchaser within 60 days from the SPA date. Just always remember, filing of CKHD form, right, is always 60 days from the SPA date or 60 days from the consent letter date, whichever is later. Okay, so acting for purchaser, after you stamp the SPA, you have to enter caveat to protect your client's interests, and then advise your client to pay differential sum, and then adjudicate MOT. So same practice, advise your client to pay legal fees during signing of SPA, but if they don't, they still need to pay before you adjudicate MOT. So you can always tell a client that if they don't pay, then we cannot proceed. So after you adjudicate MOT, you can forward the adjudicated MOT together with PDS 15 to the purchaser loan lawyer. Then once you stamp the MOT, then you forward the stamp MOT to the purchaser loan lawyer. So, okay, once the loan sum, right, i.e. the 90% balance purchase price is paid, then vendor lawyer will send to you the calculation. So you have to check. So after you check, you have to advise your client to pay. So after your client pay, you will get the keys, then you can pass to your client, and then you have to advise your client to open new TNB Shabas account and to change ownership for Indawata as well. Okay. And then the other one is free from encumbrances. So this is very straightforward. Then the other one, subject to restriction if you're acting for purchaser or if your client is a foreigner. So if you're acting for the purchaser, property subject to restriction, then the vendor lawyer will apply the consent to transfer. But let's say your client is a foreigner, so and there's no restriction in interest, but just that your client is a foreigner. So as a purchaser lawyer, you have to apply for consent to foreigner consent for your client. So same procedure. So the 3 months, right, will start. Will commence from the date of the foreigner consent letter. So you file your CKHD after you obtain the foreigner consent. Okay. The other one is master title. Okay, so master title, right? Okay, assuming the completion period is 3 months, standard 3 months. So after you date and stamp the SPA, it doesn't mean that the it doesn't mean that the 3 months has commenced. So the 3 months can be either from the date of the SPA or from the date you obtain the developer's confirmation, whichever is later. So, but for the filing of CKHD, always remember it's not from the date of the developer's confirmation. For master title case, right, 60 days to file CKHD is from SPA date. It's always from SPA date. So it's either from SPA date or letter of consent to transfer or foreigner consent. Okay, so for non-title, you have to write to the developer and then request for redemption statement, compile documents. So once you receive redemption statement, you have to send to the purchaser loan lawyer. And then once you receive redemption statement, you have to forward the DRR, deed of receipt and reassignment, to the vendor's bank. Then after you receive, you have to stamp and revoke the DRR at High Court and then forward to the purchaser loan lawyer. So after that, once 90% is paid, do the apportionment and advise client accordingly. Okay, then timeline number 8, field for encumbrances. This is easier. And then acting for purchaser. Mm, acting for purchaser, actually it's almost the same. So and after SPA is dated and stamped, you need to advise client to pay differential sum if there is any, and then comply with the developer's requirement in their letter. Same goes to the vendor's lawyer. If you are if you are the vendor's lawyer, you also need to check the developer's letter, see whether there's any documents or confirmation that they are requesting. Then after you receive the redemption statement, okay, then after that, okay, so once the loan, the redemption sum is released, right? So what you need to do is you have to wait for a while, because for non-title case, you cannot, it's different from MOT. You cannot adjudicate MOT before advice for redemption. So you have to wait for the vendor lawyer to tell you that, oh, we have dated the RR. Then you can proceed to adjudicate your DOA transfer and your DOA deed of assignment for security. So you have to adjudicate, pay stamp duty, and then forward to the purchaser loan lawyer for their further action. Free from encumbrances. Okay, let's discuss loan. So usually for property held under individual or strata title, so okay, in one transaction subsale, vendor can choose not to be represented, but purchaser must be represented. So if the vendor is not represented, right, so just always remember that you are acting for the purchaser, you're not acting for the vendor. Okay, and then but at the same time, we can actually act for the purchaser's fund. So means that in this in the same transaction, vendor can be not represented, but we can act for the purchaser and purchaser's fund. Okay, for property held under individual or strata title, usually the documents that need to be prepared are facility agreement 16A, statutory declaration for non-bankruptcy, owner occupation, entry and withdrawal of period, and consent to charge. So once again, you have to check the land search. And third party statutory declaration for consent to charge, and ST for first property if relevant, and Form 34 if the purchaser is a company. And then property held under master title, facility agreement, deed of assignment by way of security. So actually there are two types of deed of assignment. Transfer is something is actually similar to MOT for non-title, and deed of assignment of security is for loan. So whereby you will be assigning the rights of the property to the bank. But for deed of assignment of transfer is whereby the vendor will assign the rights of the property to the purchaser. So power of attorney, indemnity undertaking letter, all this letter is just in the event if we cannot obtain the developer's confirmation or undertaking. So we just prepare in advance. And then developers request for separate letter, SD, non-bankruptcy, owner occupation, and first property Form 34 if relevant. Okay, subsale documents for advice in general is you always need to check the bank, because different bank they have different format their advice letter. So you have to go through the advice letter to see what are the documents. But generally, the documents that are required are IC, bankruptcy search, private caveat slip if your property is under title, land search, rent assessment, management statement, fire insurance, CF, redemption statement, vendor's undertaking letter, and so and so. So and another thing, just remember, if your property is under master title, if there's a proprietor and developer, so you have to see whether there's any power of attorney granted by the proprietor to the developer. So if there is, you also need to do a search on the power of attorney at High Court. See whether the power of attorney is still valid. Okay. Okay, this is for consent to charge application. Actually, it's almost the same as it's the same for application for consent to transfer. So you can go through. And okay, this is documents for presentation purpose. So this is my sequence. Usually when I prepare presentation letter, this is my sequence. original title, you always need to check the name of the proprietor, see whether their IC is in order. So if there's any discrepancy, you have to submit statutory declaration or change of name form. It depends what kind of discrepancy. And then CTC current assessment. So if there's a caveat entered by the purchaser or by the bank, you have to withdraw. And then charge in favor of the vendor's bank if if relevant, and 16M to discharge. So if the property is subject to restriction, you have to enclose original consent to transfer and original foreigner consent if applicable. MOT. MOT, you have to take note as well, because for example, like Shah Alam Land Office, if the purchase price is more than 5 million, the biometric verification of all parties are required, and you can only make appointment to do biometric after your MOT is stamped. So far, as far as I'm aware, Shah Alam 5 million and Sepang 1 and 1 million. So, but just have to take note of. So there's other land office I'm not aware. Then after that, you have to enclose original consent to charge and original duplicate 16A charge for the purchaser's bank, their IC, and if the parties, their company, have to enclose their corporate form, resolution, CCM search. So always cross-check the CCM with their corporate forms. Okay. So this is acting for the purchaser's bank. So okay, the timeline, actually the timeline you have to follow the SPA timeline. So what you do is you prepare the loan documents, then you always have to make sure that you have received the instruction letter and original letter offer. So after client sign, you send to the purchaser's bank for execution and request for bank's LU, bank's undertaking letter. So after you receive the executed loan documents, after you receive the relevant documents, undertaking confirmation from vendor lawyer, purchaser lawyer, you have to stamp your facility agreement. Just FA first for property subject to, for property encumbered to vendor's bank. Then have to affirm and stamp the SC. Then you advise the purchaser's bank for redemption sum. And then after drawdown, so means that after you receive the redemption sum, you have to inform the purchaser and vendor's lawyer. And then you have to stamp your 16A, and you have to file Form 34 with CCM if your purchaser is a company. And after you receive the original title, stamp MOT, you have to do presentation, and you can only advise the bank for the balance after you receive the presentation slip. Okay, and lastly, you need to forward the original title and the duplicate charge to the bank and the security documents to the purchaser. Okay. And then the other one, free from encumbrances, is easier. This is more straightforward. And then acting for purchasers when subject to restriction in interest is actually the same. So means that you can do the necessary. It means that you can get the client to sign first, get the bank to execute the loan document first, and then you have to wait until the consent to transfer is obtained. Okay. For non-title case, master title case, same practice lah. Make sure you receive instruction letter, original letter offer, request developers confirmation letter, and undertaking letter. So basically they are the same. So you can just go through. So refinancing. General documents like identity card, bankruptcy search, current assessment. These are the documents required for advice. But remember, you always need to check the advice letter. Different bank, they have different requirement. Okay, actually this one is for refinancing timeline 16. There's no time limit, so you won't see these 3 months on top. But just make sure that for refinancing case, you complete within 1 to 2 months time. Okay. So you can go through, actually it's the same. It's actually the same when you act for the purchaser's bank. Okay. Yeah, I think that's all. The rest of the timeline you can refer. Yeah. So is there any questions?
Okay, so before we end this session, kindly be informed that an evaluation form will be sent to all of you via email, and we look forward to your feedback on our webinar today. I believe that's all that we have today. This marks the end of our webinar. Thank you very much for joining us.
Okay, bye-bye.